assumed office in 2017, all the cases filed by the SWA NDC government against some ministers of the Kufuor government and other appointees have been contested fully in the court and won. We secured acquittals through the court and not by resorting to delay tactics in the hope that an Kufuor appointed Attorney General would come and withdraw the cases and procure an acquittal. I speak from experience as I personally conducted some of the cases. Other lawyers within our ranks, including my colleague Deputy Attorney General, also handled same. I must state that it is clearly unprecedented for an Attorney General to hold a press conference and subject his predecessor in office to abuses and peddle falsehood in the manner displayed by Dr. Dominic Ayine. I'm constrained to set the record straight, to unveil the half-truths and manipulation of facts for well-meaning Ghanaians to decipher the true intentions of the NDC government acting through the current Attorney General and withdrawing charges against leading members of the NDC. One, it is necessary to indicate at the outset that the decision to charge a person with a criminal offense, especially in the high-profile cases at issue, which held serious implications for the public purse, involved a prosecutorial discretion exercise pursuant to painstaking investigations conducted by duly authorized investigative authorities of state, inquiries and extensive deliberations by career prosecutors in the office of the Attorney General, who indeed proceeded to conduct the cases themselves. I continue to be grateful for the advice I received from the hard-working attorneys at the AG's office, investigators and my able deputies, Mr. Alfred Tuyayeboa and Ms. Dana Sonomadapa, on the cases we personally initiated in office and the many others that had been commenced by my distinguished predecessor, Madame Gloria Efua Ekufu, which we continued. We cherished the robust discussions and debates we had whilst professionally moving forward with each of those cases. The nation would note that Dr. Ayine and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayine and other NDC personalities were, looking at the same set of facts to come to different conclusions, informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as withdrawing those cases, the only consideration has to be the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayine will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayine's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic vs. Kasser 2000 and two others, is highly disingenuous and rather, unfortunately, recaps the series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayine, who is the subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayine at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the high office of the Attorney General and Minister for Justice of the Republic. The facts relating to allegation by Dr. Ayine that I interfered with an accused person in the ambulance case are well within the public domain and have been adumbrated in court proceedings. The record shows that there has been a judicial determination of that unfounded allegation frequently made by foot soldiers of the NDC and other uninformed people. Shockingly, Dr. Ayine, the current Attorney General, ignored this fundamental fact in his 10-page press statement and over an hour conference with the media for the simple reason that he knew that his allegation had been flatly debunked by the court when same was put to strict scrutiny. If you would recall, the accused person in the ambulance trial filed an application for mistrial, hanging same on the alleged interference with one of the accused persons. On 6 June 2024, the High Court quorum or sitting through or presided over by Her Ladyship Justice Ifia Sewa Saribotri dismissed the application. You would all remember the learned Justice of the Court of Appeal, who sat as an additional High Court judge, say that she had listened to the tape in question about 10 times and found nothing to warrant a mistrial. Specifically, she stated at page 24 of her ruling, and I quote, "After listening to a conversation between the third accused and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on Exhibit CAF2. These words were uttered by A3 at about minute 09 to 10, minute 10. In the same vein, the declaration that A3 was innocent and was going through ordeal, but was being asked to help make the case to the AG better, was not made by the Attorney General, but was made by A3, to which the Attorney General responded at minute 10, second 20. And I quote, "I am not asking you to help," at minute 10, second 30. The statement that you and I have been meeting at my cousin's place at minute 10:45, etc., when closely together with A3's alleged attack of conscience, did not proceed from the mouth of the Attorney General. End of quote. The judge proceeded to state at page 32 of a ruling that the third accused, and I'm quoting, the third accused by any stretch of imagination be seen to be the one, the third accused by any stretch of imagination cannot be seen to be the one procuring new evidence or cowed by conversation. End of quote. In the face of this clear judicial pronouncement of no wrongdoing as to warrant a mistrial, it completely defies logic and good reason why the Honorable Attorney General of Ghana would say to the public that I was culpable of what he describes as a disgraceful and unethical conduct in the ambulance trial. Ghanaians want to know rather how the current Attorney General, Dr. Dominic Ayine, will deal with the complaint of professional misconduct pending Nigeria Legal Counsel against him, but no less a person than the former Chief Justice of the Republic. Ladies and gentlemen, in a chilling twist, the nation heard Dr. Ayine confessing to speaking with lawyers for the defense and engaging them on the cases that were pending against leading members of the NDC before exercising his discretion to file no prosecution or withdraw the charges. He indicated that in Republic versus Judge Kwesi, the lawyer for the accused expressed an inclination to go on and prove the innocence of his client, and therefore he decided not to enter no prosecution. Respectfully, what this betrays clearly is that the exercise of Dr. Ayine's discretion to continue the prosecution of cases or not is informed principally by the disposition of counsel for the accused in cases that the Republic is prosecuting against their clients. Thus, if counsel for the accused is in a position to strongly defend the interests of his client in court, the Attorney General of the Republic will not enter no prosecution. Where the counsel for the accused are not convinced about the likelihood of a success of their defense in court, Dr. Ayine would immediately enter a no prosecution if the prosecution has not closed his case, and a withdrawal if the prosecution has closed his case, so that an acquittal and discharge will be secured. As I will show in an examination of each of the specific cases cited in Ayine's press statement, the Honorable Attorney General quite reprehensibly relied solely on the case for the defense before exercising his discretion to discontinue the actions. He did not engage in any meaningful consultation with the prosecution's division of the Office of the Attorney General before instructing the filing of the withdrawals and no prosecution in the cases against senior members of the John Mahama government and other leading members of the NDC. The dates of filing of the said processes buttress the assertion I make, and I've referred to them already. I challenge Dr. Ayine to show any memorandum presented to him by the prosecution's division of the Office of the Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecutions, the DPP, before discontinuing the cases. You can be assured he cannot produce any. Listening to Dr. Ayine, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law on the subject matters in question. It is for this reason that the claims of alleged defect in the various charges only re-echo positions articulated by the defense counsel throughout the various proceedings. In effect, Dr. Ayine came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel on the charges their clients had been charged with. The media would notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter nolle prosequi and withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interests of the Republic in the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayine that he did not consult the former president, John Dramani Mahama, before taking the monumental decisions to discontinue the criminal cases. The cases involved the loss of colossal sums of taxpayers' money and some related to the banking sector crisis which affected the Ghanaian economy. The people of Ghana should indeed be extremely concerned and afraid by the vesting of prosecutorial authority in a person who can discontinue the prosecution of such important and high-profile cases without discussing with the President of the Republic and members of the Cabinet. Even Defense Counsel, according to him, he consulted. How much more the President? Ladies and gentlemen, we ought to ask ourselves, is it true that Dr. Ayine did not consult the President or his Cabinet about the decision to discontinue the various criminal proceedings? A careful examination of the facts shows that this claim is palpably untrue. The nation has not forgotten the loud claim by President John Mahama and the NDC that the MPP rather was responsible for a collapse of the banking sector crisis. And that on assuming power, the John Mahama government will restore all the banking licenses which were revoked. The withdrawal of the cases in question is only the first step of the clearing or whitewashing process of those whose acts led to the crisis that plagued the banking sector. Ghanaians are certainly more discerning than the NDC and Dr. Ayine think. I proceed to examine Dr. Ayine's reasons for withdrawing some of the criminal cases Dr. Ayine mentioned in his press statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betray the questionable motives for his actions. First is the Republic versus Atufossin and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense, as the defense of Dr. Atufossin. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's prosecutorial authority under Article 88, Clause 4 of the Constitution is exercised by himself or, and I quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 Act 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayine, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayine characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles purporting to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at a time that the period for supply of the ambulances and the contract had even lapsed, Dr. Atufossin, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller Accountant General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. Big C General Trading Limited, the suppliers of the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Allen Semifia, described the vehicles as ordinary vans, not fit for purpose. The defects were so irremediable that from the time the vehicles started arriving in December 2014 to January 2017, when the SR Jomama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances. And the Mahama government is back in power. I am of the honest view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayine's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayine was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Atuforsen, stand to lose by the termination of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for discontinuance of the appeal by Dr. Ayine was that he did not wish to deepen the woes of Dr. Atuforsen any further. Republic versus Ofusuampo for another. Dr. Ayine did not advance any reason whatsoever for the withdrawal of this matter, save that he was on record as counsel for the defense. I have already pointed out above the absurdity of such a position, and I will not recount. The self-serving nature of Dr. Ayine's decision is too apparent for the people of Ghana to see. Republic versus Collins, Dauda, and 4 others. The reason advanced by the Attorney General for the entry of null prosequi in the case filed against Mr. Collins, Dauda, and 4 others for their roles in the Saglemi housing scheme is that, in his view, the charges were defective. He claimed that the prosecution wrongly charged the former Minister Collins Dauda with the offense of misapplying public property, i.e. funds, in the sum of 200 million United States dollars. In Dr. Ayine's view, the prosecution should have taken into account the fact that part of the $200 million was used to construct the houses at Saglemi. With the greatest respect, this analysis by Dr. Ayine portrays a complete misapprehension of the ingredients of the offense of misapplying public funds. The offense of intentionally misapplying public property consists in wrongly applying public property, which is defined under the Public Property Protection Act of 1977, SMC Decree 140, for a purpose other than as lawfully approved. It is different from the offense of willfully causing financial loss to the state, whose defining ingredient is the actual loss occasioned the state through one's willful act. In this case, Mr. Collins Dauda was charged with the offense because he intentionally misapplied a sum of $200 million for the construction of 1,412 housing units instead of 5,000 housing units lawfully approved by a cabinet, the Parliament of Ghana, and the Public Procurement Authority to be constructed. To the question of how much was disbursed by the state during Collins Dauda's tenure as Minister for Western Housing, or the exact amount spent on the buildings when he was minister, is immaterial. The real question is whether Collins Dauda authorized the application of the sum of $200 million for the purpose lawfully approved for the project, i.e. the construction of 5,000 housing units. The answer to this question can only be in the negative. I say that in any event, if the Attorney General also the considered view that the sum of $200 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only 1 out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayine does not fault and did not talk about? With the greatest respect, the state should be seriously worried if her Attorney General demonstrates such ignorance of the basic principles of criminal law and the ingredients of offense, which border on the protection of state funds or public property. The second factor cited by Dr. Ayine for the withdrawal of the Saglemi case is the alleged failure of the prosecution to charge other ministers who took office after Collins Dauda left office. This is another palpable falsehood. The state charged all those whose roles in the Saglemi housing scheme implied criminal liability. This included Kweku Ajima-Mensah, who signed and authorized the payment of money and who was John Mohammed's Minister for Western Housing after Collins Dauda left office until January 2017. It also included a chief director, Alhaji Ziblim, who was in office until 2017, covering a part of the tenure of Mr. Atachia as minister, and signed an authorized payment of money. Dr. Ayine raises issue with the failure to join Honorable Samuel Atachia as an accused person in the matter. It ought to be made clear that the prosecution of crime is not an arena to achieve political equalization. A careful check of the facts would have disclosed to Dr. Ayine that Honorable Samuel Atachia never authorized any payment for the Saglemi project. Mr. Atachia was rather the one who called attention to the bizarre circumstances of the project and wrote a letter seeking the advice of the then Attorney General, Ms. Gloria Akufu, in or about 2019 for an urgent termination of the contract, a decision which stopped the state from unnecessary financial hemorrhage. The sum of $5 million that Dr. Ayine alludes to was authorized to be paid by the then Chief Director, Mr. Solomon Asola, and not Mr. Atachia. The decision by the prosecuting team not to charge Mr. Solomon Asola, but rather to use him as a prosecution witness, was because an examination of the record showed that Mr. Asola, in truth, tried to save the Saglemi housing project from total collapse. The sum of $5 million was authorized by Mr. Asola to be utilized for the project to save the project. Further, he assisted in shedding light on the relevant facts of the project. Hence, the prosecution's decision to use him as a prosecution witness. Prosecution of Dr. Johnson Pandit Isiama. The narration given by the Attorney General about why he is continuing the two different cases against Mr. Johnson Pandit Isiama again disclosed a litany of untruths, half-truths, and a skillful manipulation of the facts. Be that as it may, as it is with any manipulation of facts, the truth is always laid bare or being subjected to careful analysis. The first case involving Mr. Dr. Johnson Isiama Pandit, Dr. Johnson Pandit Isiama, is the Republic versus Kwabena Dufo and others, the Union Bank case. This case involved an approval by Dr. Johnson Isiama of the sum of 450 million Ghana cedis for the benefit of Universal Merchant Bank, UMB. Part of that sum was 300 million Ghana cedis, which was an unsecured facility approved by Mr. Johnson Pandit Isiama for UMB for the benefit of Union Bank Ghana Limited. The sum of 300 million cedis formed the basis of a charge of making approval in contravention of the Bank of Ghana law. The remaining amount of 150 million Ghana cedis formed the basis for the offense of willfully causing financial loss to the state. It is necessary to state that contrary to Dr. Ayine's claim, the sum of 150 million Ghana cedis to date remains unrecovered. I must indicate that I find the line of thinking of Dr. Ayine that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid, very strange and insupportable in law. Also, an amount paid in violation of the law, when subsequently recovered, does not clear the person who gave the approval to be made of wrongdoing in the first place. The anchor of Dr. Ayine's explanation for discontinuing the case against Johnson Pandit Isiama is a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, purportedly, as Dr. Ayine stated, and I quote him, recommending that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists. No such memorandum exists. I do not recall receiving any such memo from the prosecution's division. I challenge Dr. Ayine to produce such a memo for the examination of the public, as he has started saying to the public at a press conference conducted by him as a basis for his impugned actions. Curiously, when probed further on that issue in the question session of the press conference, Dr. Ayine claimed that I might have disagreed with the memo, and that is yet to know the exact reasons I made or the exact comments I made on the memo. This is bewildering and casts grave doubt on Dr. Ayine's assertion that a memo was presented to me on the issue. Will my comments on the position I took on the memo not be expressed on the memo, as is usually the case in every public service institution? How can Dr. Ayine see the memo but not see my comment in the memo? Clearly, the Attorney General set out to throw dust into the eyes of the Ghanaian populace, who in his view are a bunch of unethical people. Ghana deserves better than the tales of Dr. Ayine. Assuming for argument purposes that a memo was prepared for the consideration of the former Attorney General by some state attorneys whose ranks the current Attorney General does not specify, and on a date he does not indicate, is such a memo, I ask, binding on the Attorney General? Is the view of the state attorney binding on the Attorney General? Dr. Ayine himself alleges that he had some discussions with the DPP before withdrawing the cases in question, and that where he disagreed, he made it known to the DPP. Was the DPP's view binding on Dr. Ayine? I ask. I further ask, was it not his view, Dr. Ayine's view, of the charges he withdrew, which prevailed? If Dr. Ayine could form a view of the charges he withdrew from the court, in spite of what the DPP told him, how can he castigate Godfred Dame in the media for whatever views Godfred Dame took on the memo allegedly presented to him by some state attorneys who Dr. Ayine cannot name, on a date he cannot specify, and affecting some accused persons, again, he could not specify? And I say this because there are 6 accused persons in the matter. The question is, did the memo touch on all the accused persons? Dr. Ayine fails to indicate. I say that Dr. Ayine should, with the greatest respect, be bold to accept full responsibility for his action in withdrawing and filing no prosecution in all the cases, rather than purporting to blame former Attorney General for his decisions. Republic versus Johnson, Pandit, Isiama, and 5 others, the Unibank case, the UT Bank case. Dr. Ayine lumps up the 2 cases against Johnson's Isiama and contends that the alleged memo presented to the former Attorney General, my good self, which discussed the amount of 450 million Ghana cedis, the subject matter of charges against the gentleman in the Unibank case, also covered the UT Bank case. This is another falsehood. The sum of 450 million Ghana cedis was in respect of only the Unibank case. The UT Bank case involved the grant of approval by Dr. Johnson Isiama of 460 billion Ghana cedis facility to UT Bank in violation of the single obligor limit. Be that as it may, it suffices to note that Dr. Ayine provides absolutely no justification for a withdrawal of the charges in the UT Bank matter, save the allegation that an alleged memo was presented to me. It is also important to note that the Attorney General conceals the simple fact that the prosecution had closed its case in the UT Bank case. Thus, by virtue of the notice of withdrawal filed by the Attorney General, Dr. Dominic Ayine, Johnson Pandit Isiama was acquitted and discharged of the crimes that he had been charged with. Dr. Ayine therefore secured through the back door a whitewash and clearing of the sins of Johnson Pandit Isiama forever. Republic versus Stephen Opuni and 2 others. The reasons given by the Attorney General for the withdrawal of the case against the 3 accused persons in the Stephen Opuni case and the consequential whitewash and cleansing of sins through an acquittal and discharge again recount the misconceived perspective of defense lawyers on the charges. That case involved the loss of 271 million Ghana cedis to the state. Once again, the media would observe that the Attorney General only presented to the public the series of stories that had formed the line of defense of counsel for the accused, but completely abandoning the formidable case built by the prosecution. The Attorney General completely disregards the fact that the prosecution had been adjudged by all the courts in the Superior Court's architecture, the High Court, Court of Appeal, and the Supreme Court, as having established a case for the accused persons in that Opuni case to answer. Indeed, Dr. Opuni had closed his case. Saidu Agungu had called about 10 witnesses. Dr. Ayine, in the face of the holdings of the various courts, that there was a case for the accused persons to answer in respect of the over 27 charges filed in the Opuni case, proceeded to embark on a scathing attack on the work of the prosecution's division of the Office of the Attorney General, over which he is now superintending, as a ruse to justify the withdrawal of the case. The simple question that begs for answer is, Why would the Attorney General, who is supposed to be acting in the interest of the Republic, be arguing strenuously in favor of the Defense Counsel and against the Republic when all the Superior Court had stated that Dr. Opuni and two others had a case to answer? If the new Attorney General was of the view that the accused had a strong case and would be acquitted, why did he not wait for the accused to establish this through a trial? Is it the case that counsel for the accused told him, after his extensive discussions with them, that they were not sure of securing the acquittal of their clients, and therefore they would prefer the Attorney General to bail them out through a withdrawal of the charges? Fellow Ghanaians, in purported rationalization of the government's decision to withdraw the Opuni case, the Attorney General most bizarrely attacked the integrity of a retired Justice of the Supreme Court, Justice Clemens Onyenigwa, and the Honorable Chief Justice, albeit unjustifiably. Dr. Ayine claimed that a perjury application filed by Dr. Stephen Opuni against a witness was not heard by Justice Onyenigwa, and that, in his words, this is most unacceptable. Regrettably, this is another falsehood in Dr. Ayine's press statement. The trial court ruled on the application. The applicant proceeded to the Court of Appeal by filing a notice of appeal. I repeat that the tendency of an Attorney General to make untruthful allegations against the prosecuting team and judges sitting on cases being prosecuted by his office is highly unprofessional. What we see, and this is exactly what we see from Dr. Ayine 3 weeks into his tenure. His actions constitute an attack on the very office he is now head of. Dr. Ayine stated further in his press statement, and I quote, "When in accordance with law and practice, Justice Anochi Jima decided he was going to hold a de novo trial in the same Opuni case, he was instantly transferred to Kumasi, and the case was allocated to a new judge who then proceeded to adopt proceedings," end of quote. This is another plain falsehood, and a rehash of the unfounded allegations made by NDC commentators in the media space. If Dr. Ayine had taken pains to examine the file in the Opuni matter, as he should have done, he would have found that it was not a new trial judge who adopted the proceedings for the trial to continue. The then Attorney General, my humble self, was compelled to file an appeal against the order of Justice Anochi Jima for the proceedings to start de novo or afresh after they closed the prosecution's case and the defense had opened their case. The Court of Appeal allowed the Attorney General's appeal and ordered that the proceedings be adopted before the trial court. It took about 3 months for the appeal to be heard and determined. Before the conclusion of the appeal, the Honorable Chief Justice, in exercise of her powers under the Constitution, at the time that the proceedings in the Opuni matter had effectively been stayed due to the pendency of the appeal at the Court of Appeal, transferred the trial judge, Justice Anochi Jima, to the High Court, Kumasi, at the time that Justice Anochi Jima indeed had not even started hearing the matter at all. The display of unfamiliarity by the current Attorney General of facts regarding cases he withdraws from the various courts and speak about in the media is shocking. Ghana must be seriously worried. Ladies and gentlemen, in conclusion, I say that I deem the press conference hurriedly assembled by the Attorney General, Dr. Dominic Ayine, as a knee-jerk reaction to genuine concerns raised by well-meaning Ghanaians on the attempt by the NDC government to whitewash the crimes of persons who served in the NDC government and, as far as the law would allow, clothed them with perpetual immunity from being prosecuted for crimes committed against the Republic of Ghana. The poster adopted by the Honorable Attorney General threatens to undermine Ghana's democratic and good governance structures. I am, however, reassured by the fact that Ghanaians are discerning enough to discover the illegitimate motives for the discontinuance of the cases in question. The President, through his Attorney General, has in a spectacular fashion become the clearing agent to indemnify their allies who have duly been put before the court for commission of crimes. Thank you very much. God bless us all. my deputy attorney, my deputy is very skilled and proficient in a three language.
Fears for this country and the jurisprudence, considering the fact that your successor has discontinued some of these high-profile cases, and what different will you have done putting you in his place?
Take it now. I'll take it now.
My name is Samson Ajiman. I work with CTFM Channel 1 TV. So, Dr. Dominic Ayine's presser has received commendation because he decided to give reasons for entering nolle prosequi. Your office argued that the Supreme Court in the Gregoria Foco case. First, what is your view on that, on this approach? And second, on the issue of the aforesaid matter and your alleged conduct with respect to Richard Japa. Even though the High Court judge didn't find any evidence with respect to you asking Japa to testify in a certain way, questions have been raised as to why the Attorney General will speak to an accused person without his lawyer. And second, there were portions of the tape where you sought to suggest that he tell the court that he was unwell for the purposes of securing an adjournment. And these issues, people believe, are unethical on your side.
My name is Benis Besa, I write for the Chronicle. I did not get much of you on the perjury case in respect of the Cocoa matter. So if you can give us what the issue was about, especially what the court said and what the Supreme Court also ruled on it, if I heard you right. Yes.
Right. Okay. So I think the first question for the gentleman, what are my fears for Ghana's democracy as a result of the entry of nolle prosequi withdrawal cases? First of all, I look at everything from the perspective of public accountability. It's very important that there's accountability for all officers who hold offices which are deemed to be public trust. So if you occupy a public office, you're supposed to be a trustee of public power and authority. And therefore, one should have no difficulty at all accounting for one's stewardship. And so when persons are prosecuted for specific financial crimes and all, it assumes a greater importance because indeed it borders on the use of the public purse, which they are supposed to be trustees of and whatever. Therefore, as far as I'm concerned, there ought to be a determination of the merit of the offense that the person has been charged with. And it becomes therefore worrying when, after courts of law have established that it's a case for a public officer to answer in respect of a specific financial offense that they have been charged with, and Attorney General exercises discretion, evaluates evidence in his chambers, calls on counsel for the defense, and say that indeed that accused person ought not to open his defense and that the case is closed. It becomes more worrying when indeed the effect of that is to confer what we call in law an acquittal, which is akin to a determination of no wrongdoing by the accused person. But that's a judgment that ordinarily ought to be passed by a court of law. So my view is that once an accused person has been adjudged that's the case for the accused person to answer. There's no basis at all for an attorney general to sit in his office or his chambers to scrutinize the evidence and speak to counsel for the defense and say that the accused person ought not to answer, and even impliedly confer an acquittal on that accused person. It's unconscionable. And I would think that there's actually sufficient basis for a questioning of the provision in the Criminal Offences and Other Offences Procedure Act at 30, which effectively confers on the Attorney General the power to pass a verdict on a crime that has been that a person has been charged with. But effectively, if that's the case, then it means all an Attorney General should do, especially, I had been a holder of the office, I can cite myself. So various allegations have been made against certain ministers, maybe without any basis at all. I just can collude with Minister A and say, Minister A, let's quickly file a case against you in the course of Ghana. Once the case has been filed, we call a few witnesses, close our defense, and then close our case, call upon the accused person to open his defense. Once it starts, then I enter a withdrawal, and the person would have been acquitted. And there cannot be a reopening of that case. Because once the person has been acquitted, it ends the matter. I think it provides basis for sufficient abuse, especially in all these cases. You saw there's a case that had been made, the court held that Saglemi was a case for him to answer, Saglemi and two others. They went all the way up to Supreme Court. They did not succeed. Same happened in Thompson. Some count, the court said, indeed, there was a case for him to answer, as well as Ofuswampo. Ofuswampo, for the same day that Atufosi was acquitted by the Court for Appeal, the same panel actually held that Ofuswampo had the case to answer. And subsequently, the Attorney General comes less than a year and says the person has no case to answer. So that's my view. It provides basis for abuse, and indeed, you must look at it from the point of public accountability. An Attorney General, by the exercise of such powers, and effectively shield members of the public from public accountability. Then, commendation by various persons for the press conference by Dr. Ayine. Yes, the Agogo Afoku matter. So you must make a distinction between legal principles of law and what may be allowed. Or what may be proper. So, in the eyes of the law, the exercise of the power of no prosecution is not subject to questioning at all. So, when the Attorney General contends in court, which I did when I was Deputy Attorney General in the Oku matter, that the then Attorney General, Madam Gloria, was not required to account for the entry of the no prosecution. That position is correct, but no prosecution is one of the means by which the Attorney General controls the conduct of prosecution. And indeed, I find it a little bit innocuous because it doesn't result in an acquittal of an accused person. It doesn't result in the Attorney General exercising the power to pass judgment on the conduct of any accused person. And no prosecution only results in a termination of proceedings. A future Attorney General who finds merit in the case can revive it and go to court. Indeed, the same Attorney General may even just want to reorganize and come back, which we did actually in the Afuku case. The entry of no prosecution was because they had arrested the second culprit in the matter, whose role was deemed to be crucial. And the then Attorney General deemed it fit to commence proceedings again. And we did it. We didn't just enter no prosecution and whitewash the person's crime. So I think that if an Attorney General decides to open up on the reasons for entry of no prosecution and withdrawal, well, it's something that is permissible, but of course it's not legally the Attorney General is not legally compelled to do that. And indeed, I have on many occasions actually issued press statements, as we all know. Record shows I issued press statements even after the court ordered a mistrial in the Afuku matter and other matters explaining. So it is something that I think that ought to be tolerated and ought to be encouraged and all. But the fundamental question is, what were the motives for the press conference? And as I've disclosed, the motive for the press conference was just to whitewash, or just to explain. He himself knew that there had been a public backlash, there had been a reduction of the goodwill that they thought the NDC had in the beginning by the entry of these withdrawals and all that. The public was really appalled by the manner in which these withdrawals were done, especially when important in the use of the public funds. And those were really the true motives for the holding of the press conference by Dr. Ayine and nothing more. And regarding Richard Japa, yes. So I think that, as I said, the full facts were actually unraveled in the course of court proceedings. The tape was played many times. Even when Japa was in the witness box, the tape was played again. I proceeded to cross-examine him. The DPP had earlier on cross-examined on allegations affecting me personally because I deemed that no, you cannot be saying things. I said this, I didn't say that, and that kind of thing. It becomes a little bit awkward. So the DPP exercised I told the DPP to conduct that part. In the main cases, the main case affecting Japa, I did that. When I was cross-examining, he never even brought it up because he knew the allegations that were made in the media were totally false. The true facts are simple. I've never met Richard Japa anywhere in my life apart from the courtroom and on a few occasions in the house of a Justice of the Supreme Court, Justice Yoni Kulendi. And that's because I have never arranged any meeting with him. I mean, Justice Kulendi is a very respected figure in Ghana, a former member of the same firm that I trained, the Kufari Pepenko, and we had good relations before he became a judge. In fact, it's even important to note that the house that I live in, which I bought in 2014, I bought it from Justice Kulendi's client. So we have had that when he was a lawyer, practicing lawyer, and I don't think he even wanted to go to the Supreme Court at that time. So we had that very good relationship and all. So a few occasions, maybe a Christmas party, Easter time, and that kind of thing, I'll go to Kulendi's house. Occasionally, he will call me. He had not seen a long while. Oh, I'll come over, and I come over. Then I met him on those few occasions. The interactions we had did not bother anything at all. And indeed, on one of the visits, the very last visit, I knew that he was not well. It's a matter of record. And the record of proceedings in the court showed that even the day in question, his own counsel had called the DDP to arrange an adjournment because he knew his client was not well. And the case came on, the judge asked the lawyer for the accused actually requested that they go into chambers and discuss matters bordering on adjournment. Again, because of the awareness of Richard Japa. And they went, and because of the awareness of Richard Japa, an adjournment was granted. Incidentally, that week happened to be the week just preceding an international arbitration that I had in the United Kingdom. As a matter of record, look at all the dates and all. The hearing of the GC net matter, which subsequently the government of Ghana won, was on the Monday after the secret recording by Richard Japa, which was on either the Tuesday or the Thursday. So, and the international arbitration proceedings are so voluminous. And whilst in office, I cultivated the habit of conducting most international arbitration cases ourselves. Myself and my deputy, Dana, Snowball Dapa, and all who will go with other state attorneys and all. So the case against Richard Japa used to come on Tuesday and Thursday. By the Thursday, if you attend, you have burdened with a lot of work. Cabinet, National Security Council, court, everything. You must try and do all together. So on the very Thursday, I think it was the Thursday or so, Tuesday or Thursday, I realized I had to really prepare for the international arbitration. Otherwise, the hearing that was supposed to come up the next Monday, I would be very much troubled. So by 12 p.m., by 11 a.m., and the matter was becoming at 12 a.m., I realized I was still not really ready or in a position to do my study. And that was a single phone call that I made to him, which was the serious matter of the proceedings. And so I went to call him just to, because indeed I knew he was not well. And that day, as I said, he actually went to court and got an adjournment because he was not well. I just called him in that conversation, not knowing he himself had that illicit agenda and was secretly recording and was saying the things that he got on the tape, which the judge said that those things, if you look at them, came from him and not from me. That's why I said, so you yourself, I mean, you're not well the day I met you. So is it possible? He said, he's afraid because the judge had earlier on, it was a matter of fact as well, issued a bench warrant for his arrest. And so he was afraid to obtain or to apply for excuse from court proceedings on basis of being unwell. I said, well, you can get a medical report. That's exactly what happened. Then he said, well, it's a little too late. He's afraid of the judge. And they went. But when they went, he actually obtained adjournment because it was not well. So the fact of my asking him to obtain medical certificate because it was not well was nothing but factual. Was not an attempt to get him to procure any evidence or anything at all. That is it. And then you asked about why did I speak to him with absence of his counsel? I've told you exactly the circumstances that led to that, which of course he manipulated and all that. And you will see that Ayine says you're consulting counsel for defense. The question is whether Ayine consulted counsel for defense in the presence of the DPP and all that. Clearly, all those conversations Ayine had with counsel for defense, the DPP and co were not present, acting by himself. These are matters that you can look at. Anyway, I made a question. Yeah, which question was that? Right. On the perjury, yes, so I state perjury application was ruled upon by the judge and the applicants who were the accused persons, and for that matter, they appealed to the Court of Appeal. So it is not correct that the perjury application was not determined by the court. And it is not even unusual for a trial court to say that the ruling on your application will abide the determination of the main case. If you are guilty, you can appeal, which they did. I don't think there's much more. Right. Yes.
My name is Mutala Inusa. I work with the EIB group, GH1 TV and Star FM. I want to find our respect to the Saglemi affordable housing matter. The sum in question is $200 million. So Alhaji Collins Dauda and then the four others, unfortunately, one of them is deceased now. In the course of the trial, I remember when the very first prosecution witness mounted the witness box, Reverend Yao Osei. One of the issues that came to the fore was that if you look at the sum of $200 million, charges alone amounted to over $1 million. And therefore, on what basis are you charging Alhaji Collins Dauda to have expended $200 million when charges took away some of the money? Number two, Cocoa Board. One of the things that Dr. Ayine indicated was to the effect that prosecution called 7 witnesses to tell their story. Out of the 7, there is no end user, that is the farmer, who testified. Dr. Buni called 10 witnesses. Majority of them are farmers and end users. Come again. Yes, farmers. Seido Agongo was in the witness box with its witnesses, and it was also calling end users of Litoville liquid fertilizer. From the prosecution point of view and the strategy that the prosecution adopted, is there any of the evidence that the scientists were coming to by way of give witnesses or give evidence vis-a-vis somebody who has called end users of Litoville liquid fertilizer to say that, yes, I built my houses when I used Litoville. Yes, I bought my cars when I used Litoville. If Dr. Ayine is saying that, continue with this trial, it's a waste of state resources. And for that matter, I want to truncate it. Don't you think it's in order, it's expedient enough? Thank you.
Right. So, first question.
Okay. So my name is.
Okay, I think the first question is whether why did you charge for Dauda for $1 million or for $2 million? Where the sum is $2 million. It is never true that we charge for Dauda for financial loss in the sum of over $200 million. Indeed, each of the financial loss offenses is built around a specific sum that an accused person can't actually be held to have cost. So, rather authorized the payment of certain sums when he was in office. They didn't amount to $2 million. Those form the subject matter of the offense of willfully causing financial loss. And as I say, it must be distinguished from intentionally misapplying public property, which is his authorization for the application of the whole $2 million for the construction of 1,412 housing units, when indeed Cabinet, Parliament of Ghana, and PPA had approved that the entire $2 million should be used to construct 5,000 housing units. So his directing wrongly an application of $2 million for a number of housing units far less that had been approved by Parliament and by PPA resulted in his being charged with that offense. So there's really nothing wrong that's been done in the considered matter. Our charges, perhaps you are calculating because each of the counts has specific sums with which an accused person can be linked. And that's it. And then why did we not call cocoa farmers and all that? The Republic of Ghana, when it's prosecuting cases, has the benefit of properly trained scientists who can attest to the efficiency or the efficacy of a little bit fertilizer, which we did. We called scientists from Ghana, Craig, the Cocoa Research Institute of Ghana, as well as sent the little bit and all that. So the efficacy of that has been proven. There's also the opportunity to indicate whether indeed there was a direct link between little bit fertilizer and any increase in cocoa yield and whatever. So I mean, we did not need to call cocoa farmers individually to say, this one we say, oh, my farm, yes, profited from the use of little bit. And this one we say, no, it's not true. Little bit did not work for me. How do we even guarantee whether you used it little bit for? So this is a scientific matter. It's not for, with all respect, cocoa farmers. I have a lot of cocoa farmers in Wenchi. My grandfather had me, so this is not an attempt to look down on cocoa farmers at all. All my uncles are not educated with cocoa farms and all that, so it's not. But I'm saying that it's a scientific process, and we brought scientists in all this, all right?
So my name is Prince Kudoga from Joy News. I have some few questions for you. Okay. Okay, so Mr. Former Attorney General, how do you respond to claims that you are just seeking to hand down the current finance minister by hook or crook? Secondly, in your view, did the state have solid grounding in all the cases that has now been withdrawn, and do we stand a good chance of winning all the cases? And just on hindsight, how do you respond to the OSP and the former attorney and the former finance minister, Ken Ofori-Atta? Do you have any view on that? Thank you.
Is it different from the first person, the OSP and the current? Because you said first person was current finance minister.
Yes. So
okay.
You were seeking, there are claims that you were seeking to just hand down the current finance minister at forcing by hook or crook. Yeah. And now I want you to react to issue between the OSP and the former finance minister, Ken Ofori-Atta. Thank you.
Good morning, Honorable. There's a school of thought that believes that white collar crimes long time to adjudicate on it. People believe that if the pace has been quickened enough, some of these people would have been maybe behind bars by now. And because you drag the matter for a very long time, now they have gotten their freedom and they are throwing the stroke back to you. What do you take on that assertion? And then my second question, in the case of seafood, is it seafood? Blue Sea, sorry. The company made an attempt to make part payment. That the Attorney General rejected. I don't know whether he rejected it or whatever. That was a news outlet. Because people thought that could have taken the money and maybe later on pursue the criminal aspect of it. Why did you do that if you did that?
Thank you. My name is Kojo Yankson. I'm with Joy News. The Attorney General has now gone on record to state that these individuals against whom the cases have been dismissed were basically wronged by the state. Now, as a former Attorney General, how do you assess? Oh, by the way, he says that he will fight any attempts by these people who were wronged by the state to seek compensation. As a former Attorney General, how do you assess his chances of winning any such fight?
Right. So, with the gentleman who spoke about the ambulance trial being considered witch hunt, that's essentially what I addressed in my press statement. I've shown that there were indeed sufficient basis for a prosecution of the matter, and it's worthy to state that the trial court had actually stated that it was a case for the accused persons to answer. The accused persons went on appeal and succeeded through a split 2-1 decision, clearly showing that even on the court for appeal, there are some who think that it was a case for the accused persons to answer. And so, having regard to that, there was sufficient basis for the decision to be tested further in the Supreme Court. And I believe that the pronouncement by the Supreme Court would have brought finality as to the culpability or otherwise of the accused persons, including the current finance minister. And because it is not uncommon for the Supreme Court to overturn a judgment by the Court of Appeal, as happened all the time, and all. And the basis are simple, as I said. The state engaged in a transaction for the supply of ambulances. Certain vehicles reporting to be ordinary vans, in the words of the former Minister for Health, Dr. Alessibivia, were supplied. So the question is whether the state indeed received ambulances for the over 2.3 million euros that was paid for it. So the question of financial loss, no doubt, has been established. The next question will be, whose act led to the financial loss? Another question will be, the person whose act led to financial loss, were those acts willful? And willful has been defined in various cases to include even negligence. If we're supposed to do something in accordance with due process, in accordance with requirements of the agreement, did not do so. That's it. The agreement required that there ought to be pre-shipment inspection before. The Minister of Finance may not be the one to conduct pre-shipment inspection, but it is the guardian of the public purse. The Minister of Finance is the one which pays money to public purse. Even when I was at Angela, many times we sent requests for payment for XYZ, which the Minister for Finance will query, has not been in accordance with the budgetary limit and all that. So before Minister for Finance authorizes payment, there must be satisfaction of the due process, and that due process includes that there must be a warrant, the basis for the payment. So if an agreement has clearly not been to Parliament, has not received parliamentary approval, and indeed was a commercial agreement between government of Ghana and a foreign entity doing business with the government of Ghana, that agreement cannot even be said to be valid. But that was the opinion that was given by the Attorney General, the Deputy Attorney General, the then Deputy Attorney General, and Dominic Ayine, that the agreement, which was a commercial agreement which had not been signed, which had not received parliamentary approval, commercial agreement between a Dubai-based company and government of Ghana, which had not received parliamentary approval, has satisfied all the parliamentary all the statutory approvals. No, definitely was wrong. Apart from that, per the contract, the terms of the contract, the steps that ought to have been satisfied before payment will be due had not been satisfied. So, on what basis would a Minister for Finance or the Deputy Minister for Finance authorize payment? So clearly, there was basis for charging the accused persons with offense, and I believe that if the appeal had not been withdrawn, the appeal would have been successful. But it's up to the Attorney General. You asked a question also about OSP and Mr. Furiata. For me, I think it's also important to state that whilst in office, having regard to the requirement for independence of the special prosecutor, I never, on any occasion, interfered with the work of the office of the special prosecutor. If you would notice, there was never a moment on which I met the OSP. I gave him complete independence to do his work. And that's because it's a requirement of the law that we promoted and all that. But of course, the OSPs act just like those of the Attorney General, subject to law and scrutiny by the courts of Ghana. So if the OSP does anything that will appear to be an overstepping of his bounds, no doubt the court can call him to order, just like actions of the Attorney General all the time are questioned in the courts, and decisions by the President of Ghana are even questioned by the court. I think that what happened this week between the OSP and Saglemi Frata was rather unfortunate, because before a person can be seen to be avoiding the requirement of criminal process, it ought to be an account of that person having been subjected to a process before. And I read of correspondence between lawyers for Mr. Frata and the OSP, by which within a period of just about 2 weeks, the OSP had been notified that Mr. Frata was out of registration. And indeed, he has been out of registration since 3rd or 4th January. So it is not, and he went out of registration before the OSP started requesting the attendance of Mr. Frata. So it is not as if there was a request for the attendance of Mr. Frata at the offices of the OSP, and then Mr. Frata traveled out of registration. He left the country 3 clear weeks before the request by the OSP was made. And once it was made, it was not ignored. Frata responded and stated through his lawyers that he was out of registration. So I find the actions of the OSP, the greatest respect, a bit unnecessary. I felt that could have been avoided, and that maybe lessons will be learned, I'm sure. So that's what I can say. But as I say, you see how reluctant I am. I'm really all the time constrained to make. I never even made any statement at all when I was in office about the OSP, if you remember. The only occasion on which we had to act was when he himself referred the matter to Yoko, and Yoko sought our advice. Of course, even before he was referring the matter to Yoko, he himself had cleared Sisi Adapa of any wrongdoing. So then, white collar crime, yes, taking long to resolve. It's a very important question, and it is one that I sought to cure when I was in office. All the delays in relation to the prosecution of the various financial offenses can never be attributed to the Attorney General. We all in Ghana, we saw the defense, counsel for defense resort to all manner of tricks to delay matters. I can count as many as about 47 interlocutory applications filed by Dr. Stephen Opuni, as well as about 15 appeals filed by them. And I think that it is a situation that the judicial service of Ghana or the judiciary must really deplore and not to take a serious view of it. Many times I complained about it in the media, the delay in the prosecution of these financial crimes, because I recognize that if it is efficiently prosecuted, it could actually it will serve as a very, very positive signal for the country, because it could deter the perpetration of such offenses by persons who hold public office. And therefore, and it's also quite ironic that the NDC would orchestrate such delays only for them to come to power, discontinue the trials, and now, as I hear, even in the social media domain, some commentators will turn around to blame the prosecution for such delays. All the interlocutory appeals were filed by the accused persons. They filed applications from the High Court all the way to Supreme Court, and even in Supreme Court rules, there will be a review and what have you. So, when I was in office, I sought to introduce a bill, which is a Criminal and Other Offences Procedure Amendment Bill, to ensure an expeditious determination of all criminal cases. The bill went to Parliament, got through to a second reading, and then the chaos in Parliament occurred, and the bill was not passed. I quite shockingly heard the new Attorney General express quite a bit of lack of interest in the bill at his vetting. And I'm surprised, because if an Attorney General is supposed to really be interested in the expeditious determination of criminal cases, he is the Attorney General now. Let's see what he will do about it. And then there was a question by Mr. Kojo Yankson.
Nana Kojo Ayine.
Of Big C. Yes. Because we act in accordance with due process. The request was made by counsel for the defense. I will say that a company which was not a party to the transaction would offer to pay and the case to end. So the DPP, the Director of Public Prosecutions, wrote back to the counsel for defense that does this, by any implication, mean that you are submitting yourself to plea bargaining? There's a new plea bargaining law which I introduced again when I was Attorney General. Are you coming within the premise of that? And then they wrote back, say, no, they're not coming under that law. And so how are you going to do it? There must be a law which regulates performance or the taking of every step by the prosecution. So on that account, we went through the proceedings and all. But of course, now they're in government. The same counsel for the defense who made those proposals. In fact, even the third accused who got the proposal is also in government, which Japa is in government, so the Attorney General can pursue them for the money. So, I mean, the state should not be, should not suffer at all. Mr. Could you answer this question?
Final question.
Did the Attorney General was wrong or something like that? Right.
These people were wrongly prosecuted, so the state has wronged them. He also says that if they seek compensation, he will fight. How do you assess his chances of winning any such?
Very high, because he knows that the prosecution was not malicious. The basis for such a claim by any accused person is when there's malicious prosecution. It's actually what we call a tort. It's a civil wrong. The wrong of civil. So the fact that a prosecution even fails doesn't mean that the prosecution is malicious. Malicious prosecution is when, without any basis whatsoever, you file charges against an accused person just to chat him up or to intimidate him or to harass him. That's why you must be careful before you exercise prosecutorial authority. This cannot be the case when many of the accused persons have been held by the court to have a case to answer. Okuni, Fusuan Pofu, and the Storm Scene, and all the other cases. Because even we are at the submission of no case stage when it is discontinued. And the basis were clear, and I've showed from what I've stated here that none of the cases can be subjected to the attack of malicious prosecution. So he knows that the chances of his success in those cases is very high. That's because our prosecution was not malicious. So I'm sure that if they file such a claim, it will dismiss.
Okay, ladies and gentlemen, thank you so much for attending on this press conference. I'm sure that the Honorable Dina Asunaba Dapa will take us through a key treatise and summary of what is happening. And so, Honorable, please wait. Honorable Dina Asunaba Dapa, I'm about to offer Amayina, then we can take it from there.
Medasipi. Wait.